This has happened before, but we have been advised that in the next case, 129-088, Collins versus the Kansas Department of Revenue. That's your case, correct?
Yes.
Counsel Marissa Jones is quite ill and is unable to attend today. And so she is submitting her argument on the brief. So, counsel, if you want to enter your appearance, we will certainly entertain your argument today, but I'm not going to grant you any rebuttal. Yeah, do it for the first time and we'll call it good.
May it please the court, Tyler Childress for the appellant Micah Collins.
All right, thank you.
Let's cut to the chase.
Sure.
You know, this is my old bailiwick, DUIs. I heard hundreds of them over the court, probably thousands. So in this case, the police officer pretty upfront says, I didn't base the stop. I didn't base my suspicion of him being under the influence on the 3 times he didn't signal. He focused it on the smell of alcohol from coming within the vehicle when he got up to the car, and his testimony that he almost hit a car as he pulled over. Is that correct?
I think on the issue of the turn signal, whether it was 2 or 3 times, he very clearly never signaled twice. The final time he signaled, I think, as he's stopped at the stop sign,
I
which
watched the video, and it looked to me like 3 times, but it doesn't matter because the officer I mean, most officers would say, yeah, he didn't signal and then he did that, but
Right.
this officer said, no, that didn't make me suspicious.
And I would agree that that was his basis. We take issue with almost hitting a parked car. When you watch the video, Mr. Collins clearly in one continuous motion pulls to the side of the road appropriately, as Judge Goddard's noted in his memorandum of opinion. He said that while almost hitting a car, he did pull over appropriately. The testimony of swerving to miss the parked car, that's not borne out by the
Or
video.
almost hit is what the judge said
Correct.
after viewing the video.
Correct.
So on that fact, that's a factual determination by the judge, right? We don't get to replace, or do we look at the video and make our own conclusion about whether he almost hit the car?
I think when you have a mixed standard like this, you do have to look at the evidence that was presented and determine, is there substantial competent evidence? My argument would be the video does not bear out what the testimony was, is not consistent with what the judge's ruling was. But I will say on the trial court level, I disagree with Department of Revenue that the statement by the trial court that the bloodshot eyes and the admission to alcohol was only going to probable cause. In the memorandum decision, it very clearly states bloodshot eyes, admits to drinking, and then Judge Goddard says clearly the officer had sufficient reason to require the plaintiff to undergo field sobriety testing, indicating that the trial court did consider 2 pieces of information that Officer Dow did not have when he made the decision to initiate the DUI investigation. I would also
What
add
2 pieces of information didn't he have?
bloodshot eyes and admission to drinking. Those 2 only occur after Mr. Collins is taken out of the vehicle.
Okay.
Didn't he
So-
say that he saw the blood, sorry,
No, that's okay. Go ahead.
didn't he say he saw the bloodshot eyes as he was asking him to stop out when he like approached or like was at the window? And as he was coming out or asked him to come out, that's when he saw it?
So there is in the preliminary or in the trial transcript, there's a question asked by Mr. Bath, did you see the bloodshot eyes after he got out of the vehicle? And the answer is yes. He already made the decision to extend the stop as he's approaching the vehicle. And so I think even if we take the view of he makes that observation when he's asking Mr. Collins to step out of the vehicle, the decision has already been made at that point that he's conducting a DUI investigation. I think it's also important when we're looking at the case law we've cited to, all of those cases, even ones cited by the Department of Revenue, the suspect or the driver, they smell of alcohol. It's attributed to the driver, and the driver admits to drinking some quantity of alcohol. Here, Mr. Collins has just told the officer that he's picked up two of his friends from the bar. Officer Dowd testified at the trial that he did not have information that Mr. Collins himself was in the bar, only that the two friends were in the bar.
Okay, so he steps up to the car. He says, I smell, I think he said a strong, pretty strong odor coming from within the car. So are you saying you don't think he had the right to ask the gentleman to step out of the car so he could determine if the smell was coming from him?
Under these facts with two other passengers, we do not believe so.
You don't think he could even ask him to step out to try to determine if it was just the passengers he's smelling? He should just let them go on down the road.
Correct, Judge. Under these facts, we do not believe that there's a basis to pull that driver out of the vehicle, with the basis of the stop being improper use of turn signals.
So whenever I'm in a car and the police smell the odor of alcohol in the car and there are several people in the car, I get a pass.
I don't think it's you get a pass. I think it's the law clearly states that the smell of alcohol, admission to drinking, and sometimes even other facts, when you look at the Mosier case, those facts alone do not give you the basis to extend the stop and turn it into a DUI. Any law-abiding citizen can have a beer when they're out for dinner, when they're at an event, can get in their vehicle, and are not necessarily committing the crime of DUI. And so that smell alone does not give them the basis to pull them out, because
Okay,
In
so
your-
if it was only him in the car and he smelled the odor when he came up to, a strong odor when he came up to the window, that alone is not enough to get him out of the car.
if he is sitting alone in the vehicle and the officer can smell alcohol and he admits to drinking,
No, I just smell of
Okay.
alcohol. Let's not have any admission yet. Officer walks up, strong smell of alcohol, driver's sitting there. He doesn't have any right to question him further about that or prolong the stop any longer.
yes, if that's the only piece of information, I think the case law is clear that that cannot be used alone
Okay.
to extend into a DUI stop.
Counsel, I have a different question than what the other two judges. Does it make any difference that this is a driver's license? I hear a lot of these questions and your answers certainly might be pertinent to a prosecution for driving under the influence, but aren't we dealing with a question of reasonableness here when you're dealing with a driver's license review?
I think the standard, both in a criminal proceeding as well as the driver's license proceeding, is very similar. I understand that the effect is different. I understand the burden is different. Here at the trial, it was our burden to demonstrate that the agency action should not have been made. But when we're talking about the Fourth Amendment and the application of whether there can be government action, I don't believe under those circumstances there should be a distinction recognized by this court. I understand that procedurally it's different. We have more obligation than we would in a criminal trial where we didn't have the burden in that criminal trial. It was up to the prosecutor, the state, to demonstrate that their actions were lawful. But I don't think the decision of whether there's a Fourth Amendment violation and whether it was reasonable, I don't believe there's a meaningful distinction on that issue here.
An exercise of an officer's discretion in a driver's license case is held to the same standard as an exercise of discretion in a criminal prosecution. Is that your position?
My position is that when you're analyzing under the Fourth Amendment and whether there was reasonable suspicion, yes, that is the case.
You take it immediately to constitutional grounds, although there's no chance of incarceration here.
I do, Judge. It's still an impediment on the freedom of movement of Mr. Collins by extending this stop. It keeps him detained there.
Fundamental difference in what's at stake, isn't it?
Well, his right to be free from a search or a seizure, I think is very fundamental no matter what the government action is and no matter what the type of proceeding is.
You're saying this is a search and seizure?
Well, he was seized when he stopped, and the officer is supposed to advance that stop. The purpose of the stop here was not using turn signal. Unless he's got reasonable suspicion of another crime, he's got to be working towards that aim, whether issuing a warning or whether issuing some type of citation to Mr. Collins. By pulling Mr. Collins out of the vehicle and initiating standardized field sobriety testing for a DUI, he's no longer addressing the purpose of the stop. And he's, at that point, he has,
Actually, you know what the purpose of the stop is until he starts investigating. Isn't that a fluid thing oftentimes because it's based upon the facts that he discovers?
well, the basis of the investigation is he observed Mr. Collins not use his turn signal and pulls him over.
So he's limited to that.
Unless he develops additional information that develops reasonable suspicion of some
So-
other type of crime.
Then that's where the judge's questions about the odor of alcohol come in. So all these things develop during the course of an investigation.
That's correct.
It's all
Judge.
fluid. It's not, your argument is you're stuck. That the officer can't do anything after that.
My argument is if the only information he develops while investigating the known turn signal and issuing that citation is the smell of alcohol alone, and there is no other information, then it can't graduate into a DUI investigation. I'm not saying that when he smells alcohol, as he's still working on the
And
citation,
what prohibits him from going into it?
well,
Is it unreasonable then for him to further his investigation, asking him to step out and to see if the odor of alcohol is coming from him? That was unreasonable?
case law has made it clear that you don't develop reasonable suspicion of DUI based on the smell and admission of alcohol alone.
And is that Mosier?
Mosier, as well as, I am,
The key there is alone, isn't it?
well, in Chambers, Judge, I agree with you that you take everything into consideration. You consider all the pieces of information. It is fluid as it develops, but the issue is it has to develop where the officer's continuing to gather additional information. And at the time he decides to do the DUI investigation, which is when he pulls Mr. Collins out of the vehicle, he at that point in time has to have sufficient information under the law that shows reasonable suspicion that Mr. Collins has or is committing the offense of DUI.
And that's in a prosecution. But we're not in a prosecution here. We're in a driver's license suspension case, correct?
Yes, Judge.
And the standard's not different.
Not on a constitutional issue like this, because Mr. Collins is seized. So that's the government action. And in order for the government to do that and not contravene the Constitution, regardless of what proceeding the state is in, they have to have reasonable suspicion to continue the detention for the DUI, which they did not have here.
Can you tell me what the other case is you're relying on besides Mosier?
Chambers, Judge. And
I don't have your brief in front of me.
I first cited on page 8, Judge. It's
What's the site on that?
2017 Westlaw.
Okay, so it's not a published case
It's
either.
unpublished court of appeals.
Okay, so you want us to base our decision on two unpublished opinions by this court, which you're not even really supposed to cite in your brief. But, and one panel doesn't, I mean, we're not bound by two unpublished decisions. Like if these were decisions by the Kansas Supreme Court, then we would be
Sure.
bound, but we're not bound by Mosier or Chambers in any way, are we? And
Well-
you don't have any Supreme Court cases or published cases that say that, do you?
No, because no court in Kansas has ultimately decided that issue. Pullman is cited by the Department of Revenue. They explicitly say they're not going to consider or make a decision on does the smell of alcohol alone. And so if this court's view is the smell of alcohol alone allows a DUI investigation to be initiated, that's reasonable suspicion, that's your decision.
Mhm,
It would
right.
be helpful for practitioners if we had that published opinion, because it does clarify, obviously this is a line that we're kind of dancing around,
Right.
and it would be very clarifying for practitioners in that area. But I would agree, no Kansas court has definitively made that decision yet. Why Pullman is different from this case is a husband and a wife are driving motorcycles. The wife is pulled over. There's a smell of alcohol from the man himself. He admits to drinking alcohol, but there's also the added element of interference. Why that's different here and why I don't think you should reach the same conclusion as the Department of Revenue is it's very clear that He actively was trying to interrupt that investigation over an extended period of time. He pulls, I think they described one car length in front of his wife. He's told repeatedly to either leave or go over to a neighboring parking lot. He's belligerent. And that is what developed into the reasonable suspicion because his behavior was not consistent with somebody that's pulled over and listening to
here we
officer.
have the alcohol and we have the testimony that he came close to hitting the parked car. Now, whether that was swerving or whatever, I watched the video. It looks like he comes pretty close. I don't know that I could say I mean, I don't think I could substitute my decision for the district court who said it looked like he came pretty close and the officer who said he came pretty close. I mean, I don't think I would bring the officer up on perjury charges for that. I mean, it was a close enough call looking at the video of that. And the judge made that factual determination. So that's two factors you have: the smell of odor in the car and the almost hitting the parked car when he pulled over.
And the important part for us is the odor is not attributable to the driver specifically.
Right.
Other cases.
And he doesn't have
has
a
been.
right to figure out if that odor is attributed to the driver.
Under these facts, no, not to
Okay.
detain him further.
So do you disagree that the state has an interest in protecting motorists on the road from somebody that is too impaired to drive?
I would agree that there is an interest, and that's why it's balanced with when there's a warrantless seizure. The courts have made it clear that an officer can develop reasonable suspicion to conduct that investigation. So I don't disagree that there's competing interests here. Mr. Collins' ability to go about his way, the state to make sure everybody is safe and driving appropriately. And the line that we've decided to use as the balancing test is, does the officer have enough information to develop that reasonable suspicion to extend that stop into a DUI investigation? So yes, I agree, but there's also the interest of Mr. Collins to go on his way as well.
Very good. Any other questions?
I don't have any
Thank you,
more.
counsel.
Thank
Thank you
you.
very much.
You may withdraw.
Thank you, Judge.